Good morning.
Good morning.
Happy Monday and welcome to the First District Court of Appeals. This morning, we have three arguments set on the docket. The first of which is case number C-200421, Mid-Century Insurance Company versus Nicholas Stites. If attorneys can please identify themselves and their readiness to proceed.
Good morning. Carl Metz, M-E-T-Z, on behalf of Mid-Century Insurance Company, a subrogate of General Western Highland Company. We are the appellant and we're ready to proceed.
Good morning.
Good morning. Jake Bischoff on behalf of appellee Nicholas Stites, and I am ready to proceed.
Good morning. Attorney Metz, would you like to reserve time?
Yes, I would like to reserve 5 minutes for rebuttal if necessary.
All right. Whenever you're ready.
Thank you. May it please the court. This matter comes before the court on appeal following a trial court's order of November 10, 2020, granting summary judgment for the defendant. Notice of appeal was timely filed on December 3rd, 2020. The matter has been fully briefed, but just I'd like to highlight a few things that I will set forth the bases as to why the decision of the trial court should be reversed. The review is de novo. This matter is relatively simple. It stems from a fire on August 22nd, 2015 at an apartment complex called the Commons, which is owned by General Western Highland Company. Mid-Century was the fire insurer for the loss. It was a significant loss, over $2 million. The address is 121 Town Commons in Woodlawn, Ohio. The fire started on a balcony of an apartment rented to a Matthew Hochter. Matthew Hochter is a friend of the defendant, Nicholas Stites. The fire was caused by negligent smoking and discarding of cigarettes on Mr. Hochter's balcony. The defendant, Nicholas Stites, was a guest who was smoking on the balcony shortly before the fire was spotted. The defendant admits he was smoking on the balcony shortly before the fire was spotted. The defendant admits to smoking on the balcony on previous occasions, and he admits to disposing of the cigarettes improperly on a plastic chair that was on the balcony.
That was the previous occasion, right? For the day in question, he testified that he put them in a glass beer bottle, right?
Correct.
So, like, I know that your argument is, oh, we shouldn't believe him on summary judgment. There's these other factors, but you also, I mean, this is an unusual case because you have other people who were smoking at the same time. So when you have him testifying that he disposed of it in a beer bottle, which presumably would keep it from setting something on fire, and you have other people that were smoking, aren't those other causes that you would have to negate or at least address to overcome summary judgment?
I do not believe so. Number one, there were others smoking. They were all smoking up on the balcony. Number two, the bottle that he claims to have disposed the cigarette in was never located or found. Number three, and as you hit it on, it's a credibility issue because as we highlighted in our brief, there's many things he doesn't recall during the course of the day, except for the one fact that he asserts gets him out from under liability or culpability in the circumstance. And then I would also at number four, we cite to the joint enterprise theory, and we cite specific to a case. I believe it's Zachariah.
I mean, these guys were just sitting around smoking. I mean, how does that constitute a joint enterprise? I had trouble following that.
Okay. Well, they sit around smoking and they're all discarding their cigarettes as they had been in prior occasions in the corner of this balcony that has this chair, leaves, pizza boxes, as those types of things. None of them had a discussion as to, hey, wait a minute, we're doing this improperly. They could have stopped one another from smoking. or at least improperly disposing of cigarettes. I would suggest that the Zachariah decision would also suggest that the one non-smoker bared culpability in not stopping the improper disposal of the cigarettes. Certainly, he admits that he was there smoking. He admits with his friends. He admits that he'd been drinking and smoking for 5 hours. Doesn't recall the types of cigarettes he was smoking. Doesn't recall the type of beer he was smoking. Doesn't recall, at the bar that they were at ahead of time, that whether he's drinking out a bottle or a pitcher or a can. All of these factors suggest go straight to the credibility of whether or not he indeed
Well,
did.
but I think that, the issue is like, if you had someone who was involved in a traffic accident and their testimony was the light was green when I entered the intersection, even if you said, well, I don't believe that person, I think that that should go to trial. Like, you need countervailing evidence. You need someone else testifying the light was red, or other circumstantial evidence to show that the light was actually red. And so, like, what is your best evidence for the fact that he did not dispose of that in the beer bottle?
Well, I think this is more akin to the Morelli case that we cited to. And the Morelli case is very similar in the sense that that was a fire case. The fire started in the garage as a result of cigarettes disposed in a peat moss bag. And that the defendant in that case said that they disposed of their cigarettes in a glass and then put it away into a cigarette pack. And that matter had to go to a trier of fact, even though the defendant said that they had properly disposed of their cigarette butts, because the overriding evidence was that improperly discarded cigarette butts were the cause of the fire.
But wasn't there only one smoker in that case?
True. There was only one smoker in that case. And so you've got the overall evidence of, again, he was smoking on the balcony. They were seen on the balcony 23 minutes before the fire was called in. There was previous occasions where they were improperly discarding of the cigarettes. And the cause of the fire was determined to be the improper disposal of cigarettes on the balcony. So all those factors
Even
together.
there in your argument, you're using the term they, because there was more than one individual on that balcony who was smoking. And
Correct.
here we're targeting one particular individual, which is Nicholas Stites. And
Correct.
so what I'd like to understand is, how is it beyond mere speculation? In this case, when we're saying, oh, it's Nicholas Stites and there's enough to move past summary judgment. How is that beyond speculation that he was the culprit and it was his cigarette that caused the fire?
Well, it's the cumulative effect of all of them. Nicholas Stites is the one that's denied any and all responsibility. So it's certainly reasonable for a trier of fact to conclude that he was involved in the cause of the fire.
Wait, I want to make sure I understand what you just said. Are you saying the cumulative effect of all of them, meaning all of the people smoking?
Well, it's part of the joint enterprise, yes. And there's no bottle. There's no bottle that he claims that this cigarette was in.
And, going to the joint enterprise, isn't one of the requirements that there has to be an equal right to direct and govern the movements and conduct of each other? And so how does that apply in this case?
So it's just like the Zachariah case. Certainly the defendant could have had a discussion amongst the other individuals and discussed the proper disposal of the cigarettes, much like the Zachariah case, where the two moving parties claimed that they were not the ones that went out with this deer target in the roadway. They just sat in the car while the others actually did the act of putting the deer target in the roadway, which caused the accident. And the court there discussed that certainly a trier of fact, it should determine whether or not they had the ability to object and to stop the others from doing the wrong act. So with that, I think I'm coming to the end of my 10 minutes. So I will, unless there's any other questions, I will conclude my argument at this time.
Okay, and I have your 5 minutes reserved.
Thank you.
Good morning, Attorney Bischoff.
I apologize. Good morning. I'll try to keep my arguments here brief and to the point. As an initial matter, the appellant spends a considerable amount of time questioning the memory of our client, that he doesn't remember every single aspect of the day, but certainly leaves out many of the things that he did testify to that he does remember, and most importantly of which, disposing his cigarette butt into a glass bottle.
So what about the point that there was no glass bottle recovered after the fire?
I can't speak to as to why they didn't recover a glass bottle. I know there was significant damage to the property. But I guess that would in turn lead me to probably, I believe, our most pressing argument, and something that was not mentioned by Mr. Metz, is that the testimony of our client has been specifically corroborated by another individual on the balcony, Mr. Buchner, who signed an affidavit to the effect that our client did indeed dispose of his cigarette butt into a glass bottle. As to why it wasn't recovered, I'm not sure. Like I said, I know there was significant damage, and perhaps it was recovered. It just wasn't at the time deemed important. Moving on to the issue of my client's credibility. As I previously stated, not only has he testified that he discarded his butt into a glass bottle, but it has been corroborated. And Mr. Stites also made that assertion since the beginning, since the day after the fire, when he spoke to the investigator, that he discarded his butt into a glass bottle. In reality, what the appellant is trying to argue is that they don't believe him. And that's the case in any matter in which liability is disputed. One side doesn't believe the other. That doesn't mean summary judgment is not appropriate, especially when there's no contradictory evidence to the other side. As for the appellant's reliance on Morelli and Westinghouse, I would point out that those cases are clearly distinguishable. They both involve one smoker and a fire that was deemed to be caused by cigarettes. In this case, there was 4 individuals who testified that they discarded.
So what if the 4 individuals had each testified that I properly disposed of my cigarette butt in a glass bottle, and so they're all like pointing the finger, and no one is acknowledging that they discarded it improperly? What would happen in that scenario? But I mean, obviously a fire occurred to cause damage, so at least one of them has to be lying in that circumstance.
Right, and I think that would be certainly different facts, but and I wouldn't want to speculate as to what the outcome would be in that, but I would certainly point out in this case that there has been no other evidence or no other testimony that any of the other individuals discarded their cigarette butts properly, and there has been testimony by 2 individuals, my client, Mr. Buchner, that he did indeed discard his cigarette butts properly. And I guess turning to Morelli and Westinghouse, as I indicated, there's one smoker and a subsequent fire. When it was determined that a cigarette butt caused the fire, there's only but one conclusion as to who was the smoker responsible. And I would also turn to Westinghouse. In the appellate's brief, they argue that direct evidence is not required, but I would actually point to language in Westinghouse in which the court specifically says direct evidence or some kind of evidence is required before liability can be imposed on an alleged tortfeasor. And then finally, turning to the joint enterprise argument, the theory of joint enterprise is a very narrow legal doctrine. And as pointed out by the facts of Zachary, there must be a common purpose between the alleged joint tortfeasors, and then also an ability to control the actions for one another. Zachariah was a case in which the tortfeasors placed a deer stand in the middle of the road with a very clear purpose in mind, and that was to see the outcome of their actions. Here, these were just a group of friends smoking cigarettes. Their outcome wasn't any common purpose they had didn't involve smoking cigarettes, and certainly didn't involve potentially setting a fire. Finally, there is certainly no authority to act for one another. Even if Mr. Stites had appealed to the fellow individuals on the balcony, there is no indication that he had any authority to actually change their actions. And with that being said, I rest my argument.
Thank you. Attorney Metz.
Thank you. I'm just going to rebut a couple or address a couple of things. I think I can be brief on this. Counsel mentions an affidavit. The affidavit comes from a friend who had been drinking and smoking for 5 hours at the same time. He has bias as to helping his friend. Again, it's an issue of credibility. Yes, it is true that we do not believe the defendant, which is why it's an issue that should be heard for a trier of fact. Certainly, given the totality of the evidence as to what the defendant admits he was doing, where the defendant admits he was, and the result thereafter, there's sufficient evidence as to the defendant's culpability, which should be heard by the trier of fact. Again, I point to the Kilalia versus a Sears case. And in that case, it was an issue of the security guard submitted an affidavit, said that he relied upon counsel in his actions, and it was uncontroverted, but the court felt that there was insufficient, that basis alone was insufficient for summary judgment. It certainly went to the credibility as to whether or not he did actually do what he indeed said he did. So again, we believe that there's a genuine issue of material fact, and that this matter should be reversed and sent back to the trial court for further disposition and ultimate trial. Thank you very much.
Thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision, and have a wonderful afternoon.
Thank you.
Thanks.
Good morning.
Good morning, Your Honor.
Morning.
This is case number C200408, State of Ohio versus
Naya, Your Honor.
Naya. Thank you, Naya Dockery. If attorneys can please identify themselves and their readiness to proceed.
Good morning. I'm David Hoffman. I'm with the Public Defender's Office representing Ms. Dockery, the appellant. Ready to proceed.
Thank you. And Attorney Wood?
Yes, Your Honor, Connor Wood for the City of Cincinnati, the appellee, also ready to proceed.
Thank you. Great to see you both this morning. Attorney Hoffman, would you like to reserve time?
5 minutes for rebuttal, Your Honor, please.
Whenever you're ready.
Thank you. Naya Dockery's criminal damaging conviction is contrary to the manifest weight of the evidence because the trial court relied upon an obvious embellishment to find her guilty. Shayna Givens, the main fact witness, called 911 when she discovered her apartment window shattered by a brick. And she told the 911 operator that Miss Dockery did it. And the 911 operator asked her, "Did you see her do this?" And Miss Givens answered, "Yes, I seen her drive off." And then the operator asked her, okay, what color shirt or jacket was she wearing? And Miss Gibbons said, I don't know. I seen her drive off. I know it was her because I seen the car earlier today. And that exchange between the 911 operator implies very strongly that Miss Gibbons did not see Miss Dockery on foot. She even explained to the operator that the reason why she couldn't tell what Miss Dockery was wearing was because she saw her drive off.
Well, let's assume that you're right, and that is an embellishment at the testimony trial. If the testimony was simply that I recognized the vehicle, I saw someone who I thought was her in the vehicle that I understand is hers drive off right after my window is broken by a brick, isn't that sufficient circumstantial evidence on which she could be convicted?
I don't think so. I think it's enough for probable cause. I believe that the police should have investigated it based upon that, but I don't think beyond a reasonable doubt you can convict somebody just by being in the area where the brick was thrown. I don't think it's enough. And I think that intuitively, Miss Gibbons realized that. And that's why 5 months later, she came up with the story that she saw that Miss Dockery running from her apartment. I think she knew it wasn't enough. And that's why she came up with that testimony at trial. It wasn't just an elaboration on the 911 call. It was a contradiction of that call. When the trial court accepted that trial testimony, he said it was just, more details based upon being drawn out on the prosecutor's questions, but it was a contradiction. And I think the trial court was misled when it handled the testimony that way. Now you might be thinking, well, it's under oath and the 911 call wasn't under oath, but I think it's less reliable. It's less reliable, the trial testimony, because that's where the conviction is going to come from. I think there was more of an incentive to bolster Miss Gibbons' testimony at that time, and not when she was calling the 911 operator. And so I'm jumping ahead of myself here. And so from its finding, the trial court indicated that it took this trial testimony lock, stock, and barrel because it found that it was an elaboration on the 911 call when really it contradicted that call. And so the trial court lost its way, and there wasn't enough evidence without that embellishment. And so that's why the conviction is contrary to the manifest weight of the evidence. That was my argument for this morning. And I'm asking the court to find that Naya Dockery deserves a new trial because of the way this trial was handled. And I'm asking the court to reverse on that basis. If there are no further questions, I'll reserve the remainder of my comments for rebuttal.
Thank you. Attorney Wood.
Yes, Your Honor. Good morning to the rest of you. So going to kind of take off of what opposing counsels and start off with the manifest weight argument. So the contention here is that the 911 call versus Ms. Gibbons' testimony raises some discrepancies that her trial testimony should not be believed, that she is not a credible witness. In this case, what you have is Chana Gibbons, to start with the 911 call. The purpose of the 911 call is the operator is asking questions in order to elicit very specific details so that they can relay that to the officers who are responding. Chana Gibbons, in response to these questions, gave a name, identified the person who broke her window by name, stated that she saw her not only in the vicinity, but saw her leaving from the area in which she also saw that the window was broken. She saw that there was a brick nearby. You get to her trial testimony, where the purpose of that trial testimony is the prosecutor is asking questions to direct more detailed responses based on Ms. Gibbons' memory. Here she is able to, in a much calmer environment, to testify that she saw the defendant, Ms. Dockery, leaving from her window that had just shattered, that she'd heard the window break. She jumped up to the window to see what had happened. She saw that the window was broken, that there was a brick lying nearby, and that Ms. Dockery was running away from the window itself.
So I understand everything you're saying about the different purposes between the 911 call and the testimony, but that seems like a pretty significant detail, that if she had just seen Ms. Dockery running away from the window after it shattered, and in response to the 911 operator's questions, like, why wouldn't she have revealed that?
I think it's a twofold issue. Is that first, when this incident happened, Ms. Dockery was in, or Ms. Givens was in her home. Her child was there with her. It's late at night, and the patio window that they're sitting near shatters all of a sudden. So it's a very startling event. Ms. Givens runs to the window to see what exactly had happened. When she realizes that it's Ms. Dockery who's running away from that, she calls 911, is still under that pressure while the 911 operator is trying to elicit details about who she saw. And Ms. Givens does have enough presence of mind to identify Ms. Dockery by name. So when she gets to trial, it's the same type of questions that are being asked by the prosecutor that were asked by the 911 operator, but you're removing that atmosphere of, urgency, that atmosphere of being startled that Ms. Givens was under when she was answering those questions as they were asked by the 911 caller. And they're not contradictions. She tells the 911 operator, it's Nia Dockery. She tells the court, it was Nia Dockery that broke my window. She tells 911 operator, I saw her leaving from the area where my window was. She says in court, I saw Nia Dockery leaving from my apartment, my front window, which had just broken. There's a brick that's laying here that wasn't here before she got here. So there's no discrepancies there. She's not contradicting herself. She's able to add details in trial that the 911 operator was not looking for on that night, and that Ms. Givens wasn't under so much pressure from being startled by the window being broken that she's able to provide those details. And there is sufficient information that the court could have taken her testimony. They did have the opportunity to listen to the 911 call and compare her statements in the 911 call to her trial testimony. Now, the court was in the best position to evaluate Ms. Givens's credibility, to judge whether or not the pressure that she was under when she was answering the 911 calls maybe contributed to certain details not coming up in the 911 call. If the court found that her trial testimony was so contradictory as to not be credible, they would have found her not guilty, but they didn't. So in this case, the court, being in the best position to evaluate Ms. Givens's credibility, made the determination that there was enough there to sustain a conviction for criminal damaging. One other thing I just wanted to address, because it came up in the appellant's brief, was the issue of whether or not there was any testimony about the window, the damage to the window occurring before or after Ms. Givens saw Ms. Dockery. Because there is that case law that says where the victim doesn't see the damage happen in the first instance, that there has to be some testimony that the damage did not exist prior to seeing the person who is suspected of causing it in the area. On page 26 of the transcript, this question gets answered almost immediately while the prosecuting witness, Ms. Givens, is on cross-examination. Defense asks her, you heard the window break? She says, yes. Did you see the damage before or after Ms. Dockery? You saw Ms. Dockery leaving the area? She says, I saw the damage to the window after. So just wanted to address that because it was the first issue in the appellant's brief. I don't think it was discussed today, but just wanted to draw attention to that. There was sufficient evidence there for the court to find that based on that circumstantial evidence, window broke, I got up immediately, saw Ms. Givens running away. All of a sudden my window's broken and there's a brick here that wasn't here before. That conviction for the criminal damaging is supported by both sufficient evidence and is not contrary to the manifest weight of the evidence. And if the court has no further questions, I will go ahead and leave it off at this time.
Thank you. Attorney Hoffman, I'd like to start
Yes.
off by asking a question. So isn't there a certain level of frequency in which a witness or victim statement differs from one point in time to another and both versions are presented to the trial?
Well, yeah, it happens a lot. That's the main job of a trial judge, trying to parse between opposing versions of witness testimony. And
What
but
would make this case different in the sense that, if merely there being a difference in the statement, if that's enough to overcome manifest weight, then every time that there's a difference in the statements, then we're looking at reversible error.
well, for one thing, that's not really what the trial court did, was mischaracterize the difference as an elaboration, when really it was a contradiction. If the trial court recognized it as a contradiction and then made up his mind between the two versions and picked one, that would be different. But it was a mischaracterization from the get-go. He said it was an elaboration, and it was not an elaboration. It's obviously not an elaboration. And so you have the core of manifest weight analysis is whether the evidence was mishandled by the trier of fact, whether the trier of fact lost its way.
So you're saying that if the trial court had called it an inconsistency rather than an elaboration, then there would be no manifest weight problem.
No, I don't want to say that. I'm saying that it helps me that the fact that the trial court made that mistake helps me. I think it adds to a manifest weight claim, because it's a part of a manifest weight claim. How the trier of fact handles the evidence, whether it loses its way, is part of the test. And another thing,
Mr.
I
Hoffman,
want to clarify. Oh, go ahead, Judge. Sorry.
let me just ask you a quick question. It sounds like Ms. Dockery and Ms. Gibbons shared, just call him a boyfriend. And there's some evidence at the trial that Ms. Dockery was driving back and forth in front of Ms. Gibbons' apartment, yelling, honking her horn, etc. And the prosecuting witness, Ms. Gibbons, called the police, and they said there was nothing we could really do. And I know there was some testimony concerning Ms. Dockery's feelings towards this Tucker fellow. Was that proper for the court to consider that when assessing perhaps there was a motive for Ms. Dockery to throw this brick through the window, or allegedly throw the brick through the window? I guess my question is, should the court, can the court consider all the evidence that was presented, that maybe perhaps there was a motive for Ms. Dockery to do this?
Well, I think that it could be considered, but it could cut both ways. I think once Ms. Gibbons was told that the police were helpless and couldn't do anything, that would give Ms. Gibbons a reason to doctor something up to try to frame Ms. Dockery with this broken window business. And another thing, this is important. Ms. Gibbons did not testify that she saw Ms. Dockery running away as soon as she heard the thing shatter. She testified she was watching television with her daughter. She heard the noise. She went and investigated. She saw the window, saw the brick, and then she saw Ms. Dockery running away. I mean, she must be a slow runner if she's still making her way to the car after all that. I think that's something else to think about. I think those things happen when you make things up. You don't consider all the ramifications of your story. And one final thing I want to say, that you can say that the trier of fact should be the first and primary arbiter of the credibility of witnesses, but that only goes so far. I think that ought to apply if you've got a neutral record. But if you have testimony that's contradictory, where a witness contradicts herself like this, you just can't. I mean, there's got to be an extreme somewhere where that principle is not going to apply. And I think this is the case. This was a clear contradiction, and that testimony should have been rejected by the trial court. The conviction is contrary to the manifest way of the evidence, and I'm asking for a reversal. If there are no further questions, that's all I have to say.
Thank you.
Thank you.
Thank you both for your arguments this morning. We will take the case under submission, issue a timely decision, and have a wonderful afternoon and a great week.
Thank you.
Good morning.
Morning.
This is our third and final case. Cases number C2000273 and 274, State of Ohio versus Philip McConaughey. If council can please identify themselves and their readiness to proceed.
Good morning, Your Honors. My name is Laura Peters. I represent Philip McConaughey, and I am ready to proceed.
Good morning.
And John Vogt on behalf of the state, ready to proceed.
Good morning.
Morning.
Attorney Peters, would you like to reserve some time?
Yes, Your Honor. I'll reserve 3 minutes, please.
3 minutes. Whenever you're ready.
May it please the court, Mr. Vogt. This morning, I'd like to concentrate on the first 2 assignments of error unless the court has questions on the third and fourth. But to begin with, this trial started with the defense counsel making a routine and typical request for a separation of witnesses. However, before she could barely even get the sentence out, the trial court cuts her off and says the victims can be present. Presumably, the trial court was relying on Marcy's Law, Article 1, Section 10A. However, the trial court seems to have assumed that this was an absolute right of the victims to be present. This is not. First of all, the rule is not absolute because it actually requires the victims to request to be present at any proceeding. If you look at the language of A2, Section 10A and A2, it says upon request. Here, the record does not reflect any request made by Ms. Ballou or Mr. Velasquez to be present during the trial testimony. Therefore, the trial court was inaccurate in considering Marcy's Law because they had never invoked their right under Marcy's Law. Secondly, Marcy's Law is provided by the state constitution, and it's not actually really a new right. Evidence Rule 615-5B and RC 2930.09 had already contemplated victims being present during trial. However, as RC 2930.09 states, the victim had the right to be present unless it was necessary to protect the defendant's right to a fair trial. And of course,
so in this case, the trial judge did not allow counsel to elaborate on the objection, but was it still incumbent upon trial counsel to at some point make the record for how this would negatively impact the defendant's due process rights?
Your Honor, I believe trial counsel did try to put that into the record, and it's in her opening statement, in which she talks about how the victims gave inconsistent statements to the police. So what she was trying to protect was her client was the victims trying to align their testimony in order to convict Mr. McConaughey. And I did point out a couple of examples in the case where Ms. Ballou testified first, and then Mr. Velasquez testified. Mr. Velasquez had never said to the officers that Mr. McConaughey had threatened to kill Mr. Ballou or even himself. But suddenly at trial, he changed his testimony and said, "Oh yes," and he even tries to say when she tried to do that, "Oh yes, I said that. I told the officers that." Well, actually, both officers testified, no, he didn't. He never said that Mr. McConaughey threatened to kill Ms. Ballou. And also, they both had the same description of the reason why they believed that Mr. McConaughey would cause them harm was because he had this certain look in his eyes. Again, this was not presented in either one of their prior statements, but it's something that came out of trial and suddenly is aligning that the reason why they believed that Mr. McConaughey would cause them harm is because of the look in his eyes. And also, going back through and looking at the videos again, I noted Mr. Velasquez, when he talked to the officers pre-trial, or that he never talked about, he mentioned the racial terms that Mr. McConaughey used against himself and Ms. Ballou. But he never mentioned that Mr. McConaughey also called Ms. Ballou a snitch because she was calling 911. Again, he's lining up his testimony with Ms. Ballou. This wouldn't have happened if there was a separation of witnesses, before there was an improper bolstering of the witnesses' stories by being able to hear how one has testified, how the other has testified. Defense counsel pointed that out in opening, and I think it is shown in the record that that did occur, and therefore the trial court improperly abuses discretion when it wouldn't even consider defense counsel's request for a separation of witnesses. So we would request that you would find that the trial court abuses discretion when it didn't grant the request for separation of witnesses and grant Mr. McConaughey a new trial. Going to the second assignment of error, the state introduced Exhibit 3 and 4 during the Officer Yanko's Exhibit 3 during Officer Yanko's testimony and Exhibit 4 during Officer Saylor's testimony. These were statements, the body-worn camera of the officers, in order to bolster and rehabilitate Mr. Velasquez and Ms. Ballou. However, and they argue that these were prior consistent statements and therefore were allowed under Evidence Rule 801 D1B. However, the purpose of that rule is to rebut an allegation of recent fabrication, not to bolster the credibility of the witnesses.
Well, but you've just spent several minutes telling us that they basically fabricated their testimony. And so how does that rule not apply given everything you just argued?
Right. But the thing is the statements have to be prior to any motivation to fabricate. Defense counsel, so if you're alleging that defense counsel is implying that there's recent fabrication, she did that in opening statement when she pointed out how Ms. Ballou stated during the 911 call, her first statement to anybody, that he's not going to get away with this. He's not getting away with this. So the point of which the motivation to lie begins at that point, because she wants to make sure he doesn't get away with it. So she's going to tell whatever story she needs to. So therefore, the statements to Officer Yanko that were recorded on Officer Yanko's body cam video was after that statement. So therefore, they're not prior and they're not consistent, because she's testifying at trial and she's adding things that were not in those statements. So they're playing those statements, but they're not the same. They're not consistent with what her trial testimony is. They're different. So therefore they're not prior to the motivation to lie, and they're not consistent. So therefore the trial court erred in admitting Exhibit 3 and 4. So unless, I'll just briefly mention the manifest weight. So based on, we all know that credibility, that this is going to come down to credibility, and normally this court has said, it's for the trier of fact, but under the manifest weight standard, this court can look and make its own credibility determination. And in here, there's just so many inconsistencies. The fact that the trial court permitted the state to improperly admit statements that they should not have, all leads that Mr. McConaughey didn't have a fair trial, and that the credibility of the witnesses of Ms. Ballou and Mr. Velasquez were improperly bolstered. Therefore, if you take away some of their credibility because there was some inconsistencies and some of their statements are just not quite believable, we feel that Mr. McConaughey deserves a new trial. So if there's no further questions, I'll reserve the remainder of my time.
Thank you. Good morning. everyone.
Good morning, Your Honors. Opposing counsel, may it please the court. I'm also happy to just focus on the first two assignments of error and really submit on the other two.
Yeah, and Mr. Vogt, maybe if you could start with the first assignment of error and Ms. Peters' point that there was an impact on due process once you look at how the testimony changed, according to her, from the initial outreach to the authorities to the time of trial. And obviously, that's a burden of the defendant to show that there is some due process problem, but here she says that's sufficient. So maybe if you could help us out on that one.
Sure, Your Honor. You're right that the burden is on the defendant to show prejudice, and it's not just some prejudice that this court's holding from State versus Maley, that the victim's presence would result in an unfair trial, that there's particularized evidence. And it's the state's point in its brief, and I'll reiterate today that their argument in this case really amounts to nothing more than speculation. Yes, of course, I'm not going to sit here and tell you that Velasquez and Below's testimony at trial was the same exact thing they told the police. But this argument, first off, presupposes that the jury assigned special weight to the additional things that they were able to talk about at trial, which may or may not have occurred. But in any case, as I stated in my brief, a 911 call is not a deposition. When people are talking to the police for the first time at the scene of the crime, that's not a deposition. It's not their only opportunity to give a total and complete picture about what occurred. And just because they were able to provide me, it's every trial that a witness is usually able to provide additional detail at trial. So I just don't think they've satisfied their burden.
Well, let me ask you this. Maybe this is a better way of framing it. Like, if there were certainly inconsistencies that arose from the initial outreach to the time of trial, and if that's not enough for a defendant to show prejudice, like, what would the defendant need to establish?
I think a better, I think maybe what would be stronger if there were not just additional detail, but if a person told the police, that, X didn't happen, or this crime didn't happen or whatever, then at trial, they, said something completely different. There's a difference between something that's completely different than just additional detail that anyone's able to provide with specific questioning. So again, this is an abuse of discretion standard. And just one thing I'd like to point out, respectfully to opposing counsel, I don't believe the point about victims being present upon their request, that them failing to do that somehow triggered the, or wouldn't have triggered their Marsy's Law right. I don't believe that was made in the brief, Your Honor. So I ask you not to consider that in determining balancing the Marsy's Law rights versus Mr. McConaughey's right to a fair trial. I don't think the trial court acted unreasonably or unconscionably in its decision. I mean, it certainly interrupted McConaughey's trial counsel, but it told her the reason. It understood the nature of her objection. So, I mean, if she wanted reasons why or findings of facts or conclusions of law, to have the trial court, to your question about his, making a record as to prejudice, she could have asked that, but she didn't. So for these reasons, I don't think they've met their burden. First assignment of error, and ask you to overrule it. Moving on to the second assignment of error, Judge Bergeron, you read my mind. I mean, the whole first part, the first assignment of error is that Velasquez embellished his testimony, and then in the second assignment of error, they said the trial court erred to admit a prior consistent statement to rebut an implied charge of recent fabrication. So if they're right on their first assignment of error, they have to be wrong on their second. And I don't think they're right on either, but I just like to point out that inconsistency. I think they were clearly questioned repeatedly about the lack of detail in their original statements to police, whether it was on the 911 or their statements on the body cam. And again, there's a difference between, at trial saying you told police Y happened, but now you're saying X. They were clearly questioned about the additional detail they were able to provide. I think this trial strategy was to show that they were embellishing. I think that's exactly what McConaughey's trial counsel was doing. And again, the rule allows for an implied charge. They don't have to just say, you made this up, didn't you, Mr. Velasquez? It's an implied charge of recent fabrication. It's contemplated by the rule. I think those statements in Exhibits 3 and 4, the body cam, were consistent, so it was a proper application of that rule. And again, this one is also an abuse of discretion standard, Your Honors. So even if the trial court did abuse its discretion, there's also harmless error that would kick in that we'd ask this court to apply. Exhibits 3 and 4 were cumulative to other properly admitted evidence that would have been sufficient to establish Mr. McConaughey's guilt beyond a reasonable doubt. So unless there are any other questions about those two, I think for similar reasons, his convictions are supported by the manifest weight. So I'll submit on that unless there's any questions.
Thank you.
Thank you, Your Honors. Ask this court to affirm the judgment.
Attorney Peters.
Thank you, Your Honor. First, I'd like to say, I think the state has missed the point about the prior consistent statement. There has to be a prior consistent statement prior to the motivation to lie. Now, not every time a defendant or a witness is cross-examined is that going to trigger the prior consistent statement rule, nor if they're impeached. However, in this case, defense counsel did indicate when she believed any implied belief that there was a recent fabrication to lie, and that was at the instant they were reporting it. Therefore, these statements are not prior consistent statements. They do not meet the definition of 801 D1B. In that case, then, they are totally inadmissible hearsay. And also, I don't think saying that or pointing out how Mr. Velasquez changed his prior statements to line up, or added to his prior statements to line up with Blue, is saying that we're alleging he is making it, that it's inconsistent to say you can't, that our assignments
Well, it seems like
are inconsistent.
Maybe I can help you out. I mean, it seems like you have two different arguments for the two different witnesses. For Velasquez, it seems like the allegation of fabrication was recent, which was at the time of trial. Whereas for the other witness, you're saying that the motive to fabricate occurred at the time of the actual incident.
Yes, that's true, Your Honor. So it's not speculation for us to say that Velasquez changed his story, because Officer Yanko asked him twice what he goes, this, and he even kind of prefaced it with, like, it's important. What did Mr. McConaughey say to Miss Blue? What did he threaten to do? And Mr. Velasquez twice in the video said beat, and then at trial it's different, and that's why the separation of witnesses is important. However, getting to play specifically with regard to Velasquez, that was Exhibit 3, the third video is where you hear his statements, but his statements aren't consistent with his trial testimony. Therefore, again, it doesn't qualify as a prior consistent statement. He never says in that statement, oh yeah, I threatened that Mr. McConaughey threatened to kill her. He doesn't. That's why he's being able to impeach on him, and you can't use it because it's not consistent. So therefore, I mean, Exhibit 3 and 4 should never have been admitted, and it's not speculative. We pointed out that the witness, or that Mr. Velasquez lined up his testimony with Ms. Blue, because we pointed out instances. And I know the state contends that I didn't really raise the Marsy's Law issue. However, I talked about that the trial court seemed to have erroneously had a belief that Marsy's Law was absolute and that this wasn't correct. I quoted Marsy's Law, and in the quote, it clearly states that Marsy's Law says, upon request, the victim has the right to be present. I also pointed out that the federal constitution is going to trump any state constitution issue. So I definitely preserve the issue of whether or not Mr. McConaughey, that the trial court should have at least engaged in some analysis as to whether or not he had would have a fair trial if the witnesses were both present in the courtroom at the same time. So I mean, there's no waiver here. There's no new argument here. And the trial court abused its discretion when it wouldn't even engage in the analysis that it was supposed to engage in. So with that, we would request that you reverse Mr. McConaughey's convictions and grant him a new trial.
Thank you both for your arguments this morning.
Thank
We
you.
will take the matter under submission and issue a timely decision. And have a wonderful Monday.